Smita M. Patil, Associate Professor with School of Gender and Development Studies, IGNOU. Today I am going to deliver a lecture on domestic violence, which is part of BGS 012. As you know that domestic violence is a universal phenomena. In the elementary sense, it suggests the assertion of power, control, dominance in relationship. All this can be executed through means of the violence and abuse. Domestic violence is not only merely limited to the physical violence and torture, it extends to the psychological, financial, sexual, social abuse as well. Social scientists have researched on the extensive prevalence of domestic violence across societies in the world. Numerous reports point out toward the pervasive culture of the violence and intimidation against the women in their household. Patterns of patriarchal behavior and socialization experiences contribute to this threat in several ways. They are intricately linked to the understanding of social as well as the legal discourse on the issues of the domestic violence. In this lecture, we will try to learn what is the meaning of domestic violence and discuss the various dimensions of domestic violence. Now, as you know that domestic violence across the world is happening and it is a crime against the humanity. In India, domestic violence is a very deep-rooted, strongly embedded culture phenomena. Within domestic relationship, the violence against women takes many forms. It ranges from the beating and psychological torture to the regulation of the autonomy and control over the sexuality. Such form of the violence have found a separate place in the Indian society to the external that physical beating and rowdy behavior by pattern of the woman is considered normal and part of the matrimonial relationship. All of this has become integral to the commonplace experiences of women that there is hardly any reportage on such issue. The reason for the violence against women are manifold. Caste, class, religion, social norms, etc. are part of that play an incredibly significant role in the determination of power dynamics within the families in India. The intersection of the identities of the woman only further enriches the violence and dominance over women in domestic relationship. According to the National Crime Records Bureau's report in 2019, more than 30% of the crime against women were that of the domestic violence, with more than 1.25 lakhs reported cases. In 2020 itself, during the coronavirus lockdown, a number of reported cases was at of 10 years high, as reported by the very renowned newspaper, the Hindu newspaper. Violence against women in relationship is arguably the most prevalent harm perpetuated across society. Despite its universal nature and cultural roots, it is treated as an individualized phenomena. In a very illuminating piece published by the Women's Studies International Forum, Elvin Rose argues that domestic violence can be understood as a crime which is perpetuated by the state through its agent of patriarchy. This is to say that the state is facilitate the perpetuation of the violence against the subjugation of women through the established structure in the society. Thus, the partner violence become the institutionalized and legitimized in the societal discourse. There has also been a documentation of the violence against women in asylums and the persecution that women face therein. There hence seems to be a growing trend in the recognizing gender as a transnational political identity. Such an approach is unique in shifting the localized understanding of the domestic violence to a more broad and universal appeal. It needs to be emphasized that institutional support makes domestic violence more lethal and also subvert the attempt that are sought to be made through law. In India itself, that can be seen in the behavior of the police, courts and other enforcement machinery which is charged with the protection of the woman and prevention of domestic violence. The patronizing attitude of the law towards women has led to the rigid characterization of the woman in the Indian society, which is reflective of gender stereotypes and societal bias. The implications of the domestic violence are not only limited to the immediate primary victims, rather the traumatizing effect extend to family, friends and children. The multitude of the ways in which women suffer in the household creates victimhood in multiple levels: depression, post-traumatic stress disorder, seclusion, child abuse and mental trauma accompany violence that is perpetuated in household. It is a recurring phenomenon directed against the women, which implies their basic rights to live peacefully and happily. Notwithstanding the fact that the countries across the world have sought to take concrete action against this social issue, the fact that remains is that there are always limitations to which law can and cannot achieve. Hence, aim to take the discourse ahead of the law and analyze how we have reached to where we are and what are all need to strive for. And we need to understand the history of the domestic violence in India. In India, the legal framework dealing with the issues of the violence against women in the matrimonial home includes both civil and criminal penal remedies. Section 498A of the Indian Penal Code of 1816, henceforth IPC, provides for the criminal sanction in case of the woman is subjected to the cruelty by her husband or the relatives of the husband. At the same time, the Protection of the Woman from the Domestic Violence Act of 2005, hence after PWD, PAWDVA, offers civil remedies like the compensation, residential rights, etc. to the woman who is a victim of the domestic violence. However, before delving into the intricacies aspect of these laws, it will be appropriate to first understand the history and the trajectory of the feminist and rights movement in making the state to intervene in the families of the Indian citizenry. We need to also understand the penal laws. All laws aimed at prohibiting violence against women and affording protection to them are consequence of the sustained campaign spanning over many decades by various rights and feminist groups across the country. As early as 1970s, there were widespread protest and information programs which sought to bring out the discourse of the dowry into the public arena. Although the Dowry Prohibition Act of 1961 was already in place, there were intense demands for more stringent law prohibiting dowry and consequent punishment to the in-laws. Thus, the agenda was not only law prohibiting dowry and consequent punishment to the in-laws. Thus, the agenda was not only impose prohibition on dowry demands, but also penalize the earning in-laws of women. They were therefore a challenge to the established norms of the marriage in the Indian society. However, at the same time, the feminist icons had to face the severe criticism across section of the patriarchal Indian society. Not only this, the liberal democracy like India, it was an uphill task for the feminist voices to make the state to engage with the institution of the marriage and barge into the family affairs, which were considered important and integral to the traditional culture. The demand for the strict laws against dowry related offences also found intersection with the various issues of caste and class, and dowry demands were constructed as a means to assert control over the woman financially as well as sexually. Rajni Parivar argued that the anti-dowry protests in the 1970s and onwards were not merely aimed at striking the historical operation of the woman in Indian society. Rather, they were also aimed to challenge the economic dynamics of the marriage that were inspired by the commercialization of the marital relationship in the feudal capitalist Indian society. Dowry had become a very acquiring necessities of the life. It had become a business investment for the in-laws of the woman. The culmination of those voices finally led to the enactment of the Section 498A and 304B of IPC in 1983 and 1986 respectively, while 498A was broad in its scope insofar as it made cruelty to the wife by her husband or his relatives an offense, and section 304B specifically dealt with the death due to the dowry demands. Hence, the Indian civil society now endeavored to fight battles in the courtrooms. Now, what are the limitations of the penal laws and subsequent realization of a more inclusive law? The enactment of the penal law did not mean that the aim to the issue of the domestic violence. The section of the IPC were aimed to target the specific problems in marriage. The aim was to deter the husband and his relative from subjugating a woman to cruelty or the dowry demands. Given the fact that the criminal law requires higher burden of the proof and operates in a very strict domains of the interpretive framework, it was not possible to include many forms of the violence like financial or sexual abuse against the woman within the contours of the penal provisions. The patriarchal underpinning of the enforcement machinery, the lack of the sensitization programs and reluctance of the woman to report crime meant that there were needed a wholly different approaches which catered to the everyday needs and requirements of the woman in marital household in the terms of money, residence and the like. As the lawyer Indira Jaisingh argued, the role of the state was not merely limited to the prevention or deterrence for the crime against women in the household. Rather, the state also owed responsibility towards victims of the domestic violence and offer them concerned remedies and measures to make their living in a peaceful and conducive atmosphere. Such realization led to the nationwide debate on the issues of the domestic violence and loopholes and inadequacies of the existing criminal law at the same time. The National Commission for the Women, together with the various activist group, lawyers and members of the civil society, campaigned for the need for more empowering law for women which would enable them to live dignified life and avoid destitution. At the same time, such a law should also helpful in curbing and preventing the menace of the domestic violence. The Law Commission of India was tasked with framing draft bill on domestic violence in 1993, which was then discussed across academic and activist circle. Later on, the legislation sprung into action due to the pressure from the feminist group both inside and outside the country. Within the country, as we have seen, there were ever increasing demand for the comprehensive legal framework which would afford protection to the woman from the domestic violence and at the same time provide for the sustenance measures outside the country. India was party to the international treaties arrangement on the conventions like the Conventions on the Elimination of all forms of discrimination against women in 1979, which is CEDAW, the Maxim Plan of the Action in 1975, the Nairobi Forward-Looking Strategies in 1985, the Beijing Declaration and the Platform for Action in 1995, the Vienna Accord of 1994, and the reports by Special Rapporteur on the Violence Against Women. Now, international lobbying thus also played its very part in pressuring the Indian government to enact the law for prevention of the domestic violence. In 2002, a bill was introduced to the parliament for the protection of the woman from the domestic violence. Due to the certain shortcomings, it couldn't enact a law. Finally, in 2005, PWDVA saw light of the day and India ushered into regime of the legal framework to combat the means of domestic violence. Now, the domestic violence law in India, as noted above, the law relating to the domestic violence in India spreads across both the criminal and civil domains. As a facet of the criminal law, it aims at the prevention, punishment and deterrence. In the realm of the civil law, it aims to offer opportunities and support to the aggravated woman and her family. So, one has to also understand, the laws and the remedies related to it. Now, let us understand this, what is this act says, right? The Domestic Violence Act of 2005. The Constitution of India guaranteed the right to equality of the laws and equal protection of the laws to everyone and right against discrimination solely on the basis of the sex. In this light, the Domestic Violence Act of 2005 aims to provide for more effective protection of the rights of the women granted under the Constitution who are victims of the violence of any kind occurring within the family. A striking aspect of this statute is that it provides a broad definition of domestic violence and the treaties to capture the multifaceted forms of the violence and discrimination that is meted to the woman in their household. Let us understand the domestic violence as defined under section 4 of the statutes, as it says, any act, omission or commission or the conduct of the respondent shall constitute domestic violence in case it a. harms or injure or endanger the health, safety, life, limb or well-being, whether mental or physical, of the aggravated person of the tends to do so and includes causing physical abuse, sexual abuse, verbal and emotional abuse and economic abuse, or B. harasses, harms, injure or endanger the aggravated person with the view to cover her or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security, or C. has the effect of threatening the aggravated person or any person related to her by any conduct mentioned in the clause A or clause B or clause D or otherwise injures or causes harm, whether physical or mental, to the aggravated person. In such a background, it is important to note that legal rights under this act are created in favor of every woman who is in the domestic relationship, which need not necessarily be limited to the marital relationship. A domestic relationship can through conjugality, marriage, relationship in the nature of the marriage, adoption, joint family. In D. Veluswamy versus D. in 2010, the Supreme Court of India held that the relationship to be in the nature of marriage, certain conditions are important to be met. This includes the couple must hold themselves out of the society as being akin to spouse, the couple must be legal age to marry, they must be qualified to be in a legal marriage, and lastly they must be voluntarily cohabited, held themselves out to be the world as being akin to the spouses for significant period of time. Now, what are the rights and remedies under the protection of the woman from the Domestic Violence Act of 2005? Keeping this framework in mind, the next step is to recognize the rights and the remedies available to the woman under this act. It is pertinent to note that the fact that PWDVA fundamentally aims at offering opportunities and avenues to the aggravated woman to take charges of her life and come out of shackles of oppressions. As such, the Act provides right to compensation, shared household, remedies like monetary relief, protection order, residence order and custody order. An aggravated woman or a protection officer or an officer appointed under the Act, which is mandatory, or any person on behalf of the aggravated can file an application before the magistrate seeking any one or more relief prescribed under the Act. Under the section 18 of the Act, the magistrate may pass a protection order against the respondent. Thereupon, the magistrate can prohibit the respondent from the establishing any contact with the aggravated woman. This may include prohibition by entering into workplace of the woman, prohibition on the alienation of the asset of the woman, including the stridhan, and prohibition on causing any violence to the dependents or the relatives of the aggravated woman. Likewise, a magistrate may pass a resident order under the section 19 of the Act to restrain the respondent and his relatives for entering into a shared household of the couple where now the aggravated woman resides. Alternatively, the respondent can be asked to make arrangements for the resident of the aggravated woman, including the payment of the rent, if any. The respondent can ever be asked to remove himself from the household. Furthermore, the aggravated woman also entitled to claim monetary relief under the section 20 of the Act for herself and her children for any losses that they may have been suffered due to the acts of domestic violence. This relief can include the medical expenses, loss of earning and the maintenance of the woman as well as the child. Compensation can also be claimed for any emotional distress or mental torture caused due to the domestic violence. In addition, custody of the children can also sought under section 21 of the Act by aggravated woman or anyone who is acting on her behalf. An important right available to the woman under PWDVA is the right to shared household under section 17 of the Act, irrespective of whether she has any right, title or interest in the same. Earlier, the Supreme Court in S.R. Batra versus Tarun Batra in 2007 held that a shared household would only mean the house belonging to or taken or rent by the husband or the house which belonged to the joint family which the husband is a member. However, recently the judgment of the Satish Chandra Ahuja versus Sneha Ahuja in 2020, the Supreme Court overruled S.R. Batra to hold that the respondent under the DV Act is not only the husband but it can also be the father-in-law of the woman. As such, shared household would not only mean the household belonging to the belonging to or rented by the husband, but it would include any house either owned, co-owned or rented by the respondent in a complaint under the DV Act, and that the aggravated person has resided in the said house at any stage of her domestic relationship. Hence, the right of the woman also extend over the house of the in-laws where she may have resided during a domestic relationship. We need to also understand these two important things, the section 498A and 304B IPC. Considerable women population in India experiences severe physical, emotional and sexual violence in their marital homes. As noted in the preceding section, the pervasiveness of such violence forced the state to intervene into family. Prior to the civil law remedies aimed at the welfare, the state opted for penalizing measures with the enactment of the section on the cruelty to the married woman in the matrimonial household. Section 498 of the IPC provides, being the husband or the relative of the husband of the woman subjects such woman to cruelty shall be punished with imprisonment for the term which may extend to 3 years and shall also be liable to fine. And the explanation as goes, for the purpose of this section, cruelty means any willful conduct which is of such a nature as likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental, physical of the woman, or harassment of the woman, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her, any person related to her to meet such demands. A few points here are necessary to make a note of this. This section offers protection only in case of the marriage. Hence, only married women can take recourse to this section. Secondly, as held in the state of West Bengal versus Oril Jaiswal in 1994 in a criminal trial, the charges made against the accused must be proved beyond all reasonable doubt. This requirement does not stand altered in case of the section 498A IPC. Section 304B relates to the death of the married woman within 7 years of her marriage in unnatural circumstances or due to burns or bodily injury. However, in order to invoke this section, it is important to be proved that the death of the woman should have been proceeded by the cruelty, harassment for the dowry demand. The relevant portion of the section 304 reads as A as number 1, where the death of the woman is caused by any burn or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such deaths shall be called dowry deaths, and such husband or the relative shall be deemed to have caused her death. Interpretation by the Supreme Court we must know also. A reference to few of the landmark judgment of the Supreme Court merit attention here so as to clear some basic concept underlying section 498A. In V. Suvetha versus State in 2009, the Supreme Court held that for the commission of an offence under section 498A, following necessary ingredients requires to be satisfied. A. The woman must be married. B. She must be subjected to the cruelty or harassment. And C. Such cruelty or harassment must have been shown either by the husband of the woman or by the relative of her husband. Furthermore, in Rama Agrawal versus Anupam 2004, the Supreme Court observed that the expression husband in section 498A covers a person who enters into marital relationship and under the color of such proclaimed or fitant status of the husband subjects to the woman consent to the cruelty in the manner provided under section 498A, whether be legitimacy of the marriage itself for the limited purpose of the section 498A. In Vijita Gajra versus State NCT of the Delhi 2010, it was held by the Supreme Court that in order to be covered under the relative of husband, one has to be a relative of the husband by blood, marriage or adoption. As noted in U. Suvetha, the girlfriend or concubine of the husband is not his relative by marriage, blood or adoption, and is hence not covered by section 498A of the IPC. As far as the concept of the cruelty under section 498A of the IPC is concerned, it was held in G.V. Siddharamesha versus State of Karnataka in 2010 that the cruelty can either be mental or physical. It is difficult to straitjacket the term cruelty by the means of the definition because cruelty is a relative term. What constitutes cruelty for one person may not constitute cruelty for the other person. So, it is important to remember the fact that the proceeding under the IPC and the PWDVA are disjunct. Therefore, even if it is a case is being tried under section 498 of the IPC that does not preclude the aggravated woman from initiating proceeding against the respondent under the PWDVA. The same view has been affirmed by the Supreme Court in G.V. Siddharamesh case. Now, few reflections which are there in this, and one has to ponder upon this, a reflection that is related with the patriarchal realities. Well, the law has endeavored to ensure into a constitutional regime of the equality and non-discrimination, the reality on the ground is very different. Research point towards the distrust in the legal procedure and consequent out of the court settlement. Additionally, for women, the lack of the access to the courts in itself is a hurdle which is very difficult to cross. Numerous criminal cases are filed in the police station, however, a significant number of them do not even reach their logical conclusion in the courtroom. Ethnographic research points towards a large number of the settlement of inability of the enforcement machinery in catering to the protection of the rights of women. This is not only due to the prolonged legal procedure, it is also due to the fact that the enforcement machinery is heavily dominated by the men. The cross section of the state power and the patriarchal social norms push the woman into setting out the codes, whether they do not have much bargaining power, and made them to succumb to the pressure of the family and the society. Speaking of the law, it is itself insufficient and incapable to deal with issues that women face. Consider the example of the section 498A. It is fundamentally inclusive as it is only applies in the cases of the married woman. It excludes the whole range of the other women. The lack of the definite standards or the matrix to determine cruelty leaves things to the discretion of the police officer to register a case under 498A. Even where a case registered, requirement of the proof beyond the reasonable doubt places an enormous burden on the aggravated woman to get a culprit's punished. It is nearly impossible to prove everyday acts of the physical and mental cruelty that have taken place within the four walls of the home. Feminist and social sciences scholars argue that women compromises and settle because they are surrounded by the sexist culture of the recognition. In India, women who make the legal claims against domestic violence face social sanction both from the friends and the family. They also face discrimination within the criminal justice system. Even where the court passes the orders in the cases of the domestic violence, there is a still prevalent tendency to look for alternative ways to settle the dispute in question. The affirmation problem has also compounded by the patriarchal approach of the higher judiciary. For example, in Rajesh Sharma versus State of UP in 2017, the Supreme Court issued direction to prevent what is called misuse of the section 498A by women. So instead of adopting an adjudicatory approach, it is suggested, among the other things, that the lower judiciary should aim promoting settlements between the families. While these observances were later modified in Social Action Forum of Manav Adhikar versus Union of India Ministry of Law and Justice in 2018, the impact of such observation coming from the highest echelons of the justice waters down to the behavior and the conduct of the police officer and adjusters on the ground. What is also reflects is the unsuitability of the current state of the Indian judicial system to deal with the violence and discrimination faced by the women in their matrimonial life. A long path is to be, traveled by the civil society, legislature, judiciary in plugging loopholes in the current state of the affair. A structural reform with the bottom up approach is required to be undertaken. Law alone cannot ensure justice. A sustained large scale effort at combating the violence against women is the need of the hour. Social reform is a way to social justice. Women need to facilitate in taking action. Strong emphasis on the sensitization program among police officer adversaries is needed to be conducted on large scale. Till that is done, one can only hope that the things get better and the rule of law prevails. So in this lecture, I tried to emphasize what is the meaning of domestic violence and the history of the domestic violence, how international intervention was done, bringing out in the implementation of these laws in the Indian context, and what the law says and talked about. Thank you.